Right, so I've been asked to give you a sketch of our administrative cooperation with regard to posting of workers and the exchange of information that the Polish Labour Inspectorate has been involved in for quite a number of years now. So that's what it's going to be about. But before I move on to discuss the technicalities and how we started exchanging information about posting of workers, I'd like to give you a thumbnail sketch of what the whole institution is all about. The legal status of the inspectorate, the territorial division, and the remit of competence. So we operate under the Act on the State Labour Inspection that was enacted on the 13th of April 2007. And the Speaker of Parliament is the person who appoints the head of the State Labour Inspection, the Chief Labour Inspector, as we refer to the head of the State Labour Inspection. So we are quite unique in this setup from other labour inspectorates all across Europe, or most of them actually, because we do not belong to any governmental agency. We are not under the Ministry of Labour, but we report directly to the Sejm, which is the Parliament, or to be more precise, to the lower chamber of Parliament. And that's where the head of the Labour Inspection presents its annual report on the State Labour Inspection's activity. There is a parliamentary committee, which is referred to as a Labour Protection Council, which has been given the task of supervising the activity of the State Labour Inspection in Poland on behalf of the Parliament. This Labour Protection Council is a tripartite parliamentary body, which is composed of members of the government, also the MPs, and members or representatives of social partners, that is worker and employee organizations. But we also have representatives of the world of science, or the realm of science, if you like, from various scientific and research institutions sitting on the committee. Now, as far as the internal structure of the territorial division of the State Labour Inspection is concerned, as you can see, we have the map of Poland here. There are 16 provinces that the whole country is divided into, and there are just as many regional labour inspectorates or district labour inspectorates that the State Labour Inspection is divided into. Each of the individual district labour inspectorates covers, with its remit of competence, covers one particular province. There are also 42 field offices. We have a training center, which is located in Wrocław. That's where this green icon is flashing on the map. And we also have the General Labour Inspectorate, which is the headquarters of the whole institution, and that's situated in Warsaw. And that's where the liaison office for posted workers is situated. Moving on to the next slide to talk about the remit and competence of our institution. As you can see, we have a very broad remit of competence. State Labour Inspection in Poland has been charged with inspecting and supervising occupational health and safety, but also labor relations, things like working time, remuneration, and conclusion and termination of work contracts. And since the year 2007, so since the time when the Act on the State Labour Inspection was adopted in its new form, Polish Labour Inspection has also been given the task of inspecting legality of employment. And that includes the third country nationals as well. As you know, we have a huge influx of third country nationals from Ukraine, most of all, and that's what we deal with as well. But obviously, we also deal with posting of workers and the exchange of information, and temporary employment agencies. So moving on to the next slide, I'd like to refer to bilateral cooperation now. And up to now, we have concluded 12 bilateral agreements on cooperation with our partner countries from EU and EFTA member states. And out of this number, 10 agreements have been concluded to specify the scope of cooperation with regard to exchange of information on posting of workers. And those agreements were concluded with the countries you can see here: Belgium, Lithuania, Norway, the Netherlands, Slovakia, Luxembourg, Bulgaria, Estonia, Spain, and Denmark. What's interesting, most of those, or if not all of those agreements, were concluded in the period between 2007 and 2013, that is before the introduction of the enforcement directive. Now, why did we conclude those agreements on cooperation with regard to posting of workers? If you have a look at Directive 96/71/EC in its Article 4, it says that each member state is supposed to set up a liaison office within their institution that's going to be responsible for cooperating with other liaison officers across the European Union with regard to posting of workers directive. So there is a provision on the exchange of information and the setting up of liaison offices there in the directive, but there are no clear-cut and uniform rules on the scope and the remit of this cooperation. So what we decided we needed at that time, before the introduction of the enforcement directive, which specifies the scope of cooperation with regard to exchange of information, we needed agreements with our international partners, the ones that we thought it was necessary because of the volume of the exchange of information on posting of workers, the agreements that would specify the scope and the remit of cooperation. And Belgium was one of the first countries to if not the first country to conclude the agreement with Poland. That was back in 2007. And each and every of those agreements on cooperation that we signed with those 10 countries that I mentioned previously included the following rules of exchange of information. Employment conditions were included, such as working time, rest periods, annual leaves, but also conditions of hiring out workers by employment agencies, occupational safety and health, protection of women and adolescent workers, employment-related regularities, and offenses against worker rights. So quite a broad scope of cooperation, as you can see. What we did when we decided on how we're going to exchange this information, we decided to do it by means of postal services, that is by sending a letter to each of the cooperating parties, and we set the standard deadline of 4 weeks for responding to a request we received or sent to our partner country. So it was a bit of a time-consuming process sending the post correspondence and receiving it by post, but we thought it was the only way to ensure safety of the sensitive data that we exchanged at the time. So we didn't opt for emails or anything like that, but stuck to the old-fashioned postal services. So that was between the introduction of the enforcement directive, 2014/67, and then with the introduction of the with the enforcement directive in 2014, we switched to the IMI system that Ms. Carita Ramos was kind to talk about in greater detail earlier today, and that was designated to be the only official medium for cooperation. So there are the agreements that we have signed, and they're still in force, obviously, but we no longer exchange post correspondence. So we only use the IMI system to exchange information posting of workers. Now, the IMI setup, the whole IMI system, it doesn't only refer to posting of workers. Yes, it's divided into modules, And one of the modules has been devised to deal strictly with exchange of information and posting of workers. And this module is divided into several five different request forms that you can use in order to exchange information on posting of workers. There are request forms regarding the so-called urgent requests, when the requesting country would ask us about the legal establishment of a given posting employer. So whether they are registered in Poland, if they have been given the registration number, whether they have a seat there, and so on and so forth. Then there are requests concerning posting, particular posting, where you have questions about the posted workers. Then we have questions about health and safety of posted workers, if they have undergone OSH examinations, if they have medical examinations done, and so on and so forth. Working conditions such as working time and remuneration. And there are also requests to send documents to a service provider. Now, the maximum deadline for replying that is given in the IMI system is 35 calendar years, and that doesn't refer to urgent requests where you have only 5 days to answer a request. Now, besides this module on posting of workers, the requests, within the module of posting of workers, we also have the so-called uniform instrument, which allows us to notify an employer of a decision to impose a financial penalty or an administrative fine on them. And if the administrative recovery of the fine is not successful in a given member state, they can also send a request to us asking us to recover a financial penalty or an administrative fine for them. So that's what we also deal with the use of the IMI system. Now, the good and bad sides, the advantages and disadvantages of the IMI system. As you can see, there are more advantages than disadvantages. It's very user-friendly. You can't really go wrong with the IMI when sending a reply, unless you have filled all the necessary blank spaces and ticked off all the necessary sort of boxes. The system otherwise doesn't allow you to send a request. It's very safe. It's managed by the European Commission, so we're certain that sensitive data which we exchange is safe there. It's got a built-in automatic translation tool, because a lot of countries use their native tongue to ask some certain specific questions. So it's very easy for us to translate that into Polish, to see what they're actually asking us about. And it's possible to attach files and other documents when formulating a request. And the only minus that I can think of right now is the definite or the finite number of questions that sort of slightly limits the scope of information. But you can always expand the sort of information you want to receive from your partner country by attaching certain extra documents with questions, or you can actually specify the question with more information. So moving on to the statistical data, we had a look at the statistical data regarding European Union and the presentation by Ms. Ramos. Now you can see statistical data for the last 3 years that is specifically deals with Polish cooperation. And as you can see, from 1 year to the next, the number of requests that are handled by the State Labour Inspection in Poland increases by about 200. And last year we broke another record. There were almost 800 requests that we received from our member states that we dealt with. Now, with regard to the countries that send us most requests, in the second place, it's Belgium. That's always been the case with Belgium. Belgium's always been the country that sends us most requests for cooperation with regard to posting of workers. You can see Austria in the first place, but Austria is very specific in a way that it sends us most of the requests that it sends us are the requests to either send documents to a service provider or to notify them of a decision to impose financial penalty or administrative fine. In the next place, we've got France, Denmark, and we also have Latvia. Germany has fallen to the 6th, I believe, position. Yes, in the last couple of years, it used to be in the 2nd place. Now they are not as prolific as they used to be. And the questions that we get asked most frequently refer to things like legal establishment of a service provider. Do they have an entry in a register? Do they have an office? Do they for instance, have a certificate to run an agency, temporary employment agency, and things like these? You can also see that we get a lot of questions concerning the payment of social security premiums. Another thing that we get asked very often is whether the posted workers of a given service provider are legally employed in Poland, because there are a lot of third country nationals that get posted by Polish employers to the Western member states. So we need to check the legal status in Poland, and that's basically what those are basically the questions that we get asked most often in those requests for information. How do we deal with the exchange of information? It depends on what sort of information is requested of us. If a requesting country asks about the insurance premiums and the volume of turnover of a given service provider, what we do is we send a request to a relevant social insurance institution or a revenue office. So we don't send requests to district labor inspectorates asking them to run an inspection. We try to deal with those requests at the general labor inspectorates level. Also, urgent requests concerning legal establishment of the service provider are handled by the general labor inspectorate, being the liaison office. But if we get a list of posted workers, and if Belgium, for instance, asks questions concerning the length of posting or the legality of employment of those posted workers, then we have to address a specific district labor inspectorate with a question to run an inspection of a given service provider, gather all the information that was requested of them, and send it to us so that we can provide it to our requesting partner. And that is all from me. If you have any questions, I'll be happy to answer them. Thank you very much for attention.